Hi everyone, this is your favorite realtor, Norm O'Neill with Keller Williams Realty, callnorm.com. Today, I've got a great guest joining me. It's Kyle Manikas from Virginia Estate Planning Lawyer.com. And we're going to talk about probate, estates, real estate, something that comes up a lot in this day and age, and Kyle has a ton of experience with this, so I'm really looking forward to the conversation. Let's jump right in. Welcome, Kyle.
Well, thank you, Norm. I appreciate you having me. I always take the opportunity to talk to folks when they're interested in this subject. It's something I think everybody can benefit from, so if someone has an interest, I'm always happy to discuss, so thanks for inviting me today.
It's my pleasure, my pleasure. I think this conversation, and my clients definitely want to hear what you have to say about this, and I know your clients do too as well. Could you maybe start by explaining what an estate or probate attorney actually does and when someone might need one?
Yeah, no, that's a great sort of introductory question here. So there's really two things that are involved in estate planning. The first is planning for what happens when you pass away, and that may involve using a will. It may involve going to probate. In fact, if you use a will and you only use a will, you're going to probate. But it also can involve using trusts, and we'll talk today about some of the reasons that people use trusts. But in terms of the primary reasons, it's avoiding probate, and we could talk about what those benefits are. And it's also privacy, and most importantly, it's passing things on to your children in a way that is protected from lawsuits, creditors, and divorce. And that's sort of a quick upshot of the main reasons that people use trusts. There are others, but part of the planning process is getting things in order for those that you leave behind, right? You don't want to leave them a legal mess, and you surely don't want to leave them a situation where everyone's fighting, because not only is that stressful and unpleasant for them, it generally eats up the value of just about everything you left behind when people fight over it. So for those reasons, it's really important. The other part of estate planning is planning for what happens if you become incapacitated, right? If you're a younger person, maybe that means you're in a car accident, or you have a temporary illness and you lose legal capacity to make decisions. For older folks, it may be cognitive decline, it may be medical issues later in life. But if you don't have the documents signed in advance authorizing someone to act on behalf when you don't have, act on your behalf when you don't have legal capacity, then you're in a position where you have to go to court and you have to ask the judge through a petition to appoint somebody. That is not a straightforward, easy process. It is a lengthy and expensive process. But also, Norm, the person that judge appoints doesn't necessarily have to be your family member who you want, right? It can be some third person chosen by the court who then is compensated from your assets and has complete control of your life, medical, and financial decisions. And so when I sit down with people to estate plan, those are the two questions that we're looking to answer. And what I do is I start by looking at what the default process looks like and help them see what they like or don't like about it. And that informs the planning that they want to do with me.
Wow. Kyle, thank you for setting the stage with that information. As you're speaking, all I could think about was there are a lot of moving parts, and it's very important for clients to talk with you as early as possible. Would you agree with that?
Yes, I do agree with that. One, because, we don't get to schedule the time of that we pass, right? We don't know. And I think it's especially true, obviously for everyone, but I think the people who obviously in most need are the people who are older, but I think also younger, right? If you're a young couple and you have young children, it's extremely important that you think about estate planning. Not only that, you want to decide who's going to raise those children, God forbid something happens to both you and the other parent, but also you don't want your assets to be stuck in a probate process for 12 to 18 months while your young children have needs. And you cannot name a minor child the beneficiary of an insurance policy or a 401k and have it pay out when they're a minor. It ends up in court, it ends up in the probate process. However, if people with young children have a revocable trust, they can actually name the trust as the beneficiary of their insurance policy or 401k. And that way those funds bypass the court process and go directly into the trust and are there for the benefit of those children immediately. So just a couple examples, but really, regardless of age range, there is work to be done. And I think for most people, once they appreciate that, they want to get it done because it gives them some sense of peace of mind once it's completed.
And that's what we're really talking about here, right, Kyle? We want to give our clients peace of mind right when they're dealing with something stressful. How could we take something off their plate or prepare in advance to just make it a little smoother, a little easier?
Yeah, absolutely. I mean, and I always say, to some extent, estate planning is an act of love, right? I mean, you're planning and setting things up for the people that you leave behind. You want it to be easy for them. You want them to be taken care of in the best possible way. You want them to be in the most tax advantaged position, right? And all of that requires planning. And so again, it's something you do for other people. And in part, that's what makes it special.
Yes, absolutely. Absolutely. You're helping them through this. So I love that, the planning. Can you talk a little bit about the real estate and probate connection? A lot of times I know that when folks are going through this, there is real property, real estate to sell. So when someone inherits a home in Virginia, what's the first legal step that they should take?
Yeah, so it partly depends on how that home is owned. So the first thing, obviously, that determines how a home passes is the deed. So for husbands and wives, normally they take what they call tenancy by the entirety, but it has a right of survivorship, right? And that right of survivorship means that when the first spouse dies, the property by operation of law automatically passes to the second spouse. It bypasses any probate or anything of that nature. It goes directly to the spouse just by operation of law. And that's an ideal situation. Now, if somebody inherits a piece of property and it's not in a trust, then it has to go through a process called probate. You know, we haven't talked in too much detail about probate, but the best way that I can describe probate is it is a lawsuit you file against yourself after death with your own money for the benefit of your creditors. That sounds crazy, but that's exactly what probate is. And that's why so much of the planning that I do is advising people on what they need to do to avoid probate. Because, you know, one, it is a process that encourages litigation. The first thing that your executor does, and if you haven't named an executor, that means somebody you know has to come forward and volunteer for that. It's a lot of work. I mean, the first thing they have to do is, you know, one of the first things is provide a list of all your relatives to the court. And it may be relatives that you don't like, you haven't communicated with, you don't want to have anything to do with your property or your family, but they're going to get a notice in the mail in probate that's going to say that there's this estate, they may be entitled to money, and if they think they are, they should come file a claim, right? So right away, we're starting out with a process that is encouraging fighting and litigation. On average, probate takes about 8 to 12 months, and you know, again, it's a creditor-centric process, so it's designed to preserve the estate. So, you know, things are more or less frozen for that period of time so that the creditors have reasonable opportunity to file a claim against the estate. And of course, then the creditors are paid first and your family gets what's left over. So if you inherit a piece of property that's going through probate, that's great because you're inheriting property. It's not great because you're going through probate. Probate is expensive. The legal fees are expensive, the court costs, the appraisals, the professional fees. Those generally eat up about 6 to 8% of the fair market value in a good scenario. Okay, I've seen scenarios where, you know, probate's eaten up at least half of the value of the estate, right? When there's any type of dispute. So there's going to be costs, there's going to be delays. Now the question is the home paid for? Who's paying the mortgage in the meantime? These are all things you're going to have to work through the executor on. Now, the executor may be able to file a motion and get authority to sell the home in the before the probate is concluded. But again, it's a court process, right? And it's involved and it's expensive. And when you get that piece of property, you're getting it outright in your own name, right? It's as if you went out and bought it. There's no protection there. Okay, now let me compare that or contrast that for you with a trust. So if that property was owned in a trust, there's no probate, there's no executor, right? That's a good thing. There's no court process. And all those legal fees and expenses and holes or hoops that you have to jump through, those don't exist. What happens is the property is in the control of the successor trustee of the trust. And if the trust indicates you are to inherit that property, then literally it can be done in a lawyer's office in an afternoon. It's that quick and that's efficient and that efficient. So,
and then they could be full owners that easy.
Yes. Now, the other alternative is that home stays in the trust and they are a beneficiary of the trust if it's an income producing asset. And then, you know, obviously, you know, they can get the income from that property every year and then capture the appreciation. The other benefit is they get the benefit of what they call the step up in basis for that property that's in the home. So in other words, if you know about
good
this,
things
right?
about this. Tell us about it.
So if it is a revocable trust, and there's lots of different types of trusts, but the trust we're talking about here is a revocable trust, right? And that's really what 99% of people use. There are irrevocable trusts, but you only use those if you need them for the purpose because you lose other benefits. So for instance, one of the benefits you get from a revocable trust is you get that step up in basis, right? So if one of your clients, you know, purchased a home, an investment property for $100,000 and it's now worth $500,000 and they sell it, obviously they're going to pay taxes on that $400,000 they made. However, if they hold that home in a revocable trust, when they pass away, that home gets a step-up basis to the fair market value. So in other words, that $400,000 that would have been taxed as capital gains is completely wiped away, and the children or the other beneficiaries can inherit that home capital gains tax-free. Now, if it continues to appreciate after that point, then obviously they would be responsible for that. but it wipes away a lifetime of capital gains potentially, which is a huge benefit for the people that you're, leaving your property to.
Yeah, it sounds like any money that was any appreciation in the property since their relative, for example, purchased it, they received the property at the new value, today's market value.
Right.
So all of that appreciation it becomes tax-free.
Exactly
on
right.
a stepped-up basis. What a huge savings!
Huge
Folks
savings.
are saving big money on this, right?
Huge money. It's probably the most significant way that we pass wealth to intergenerationally, and I hope that stays a feature of our tax code. But from time to time, people talk about eliminating it, and that would have huge implications. And that's one of those things where maybe not a lot of people would appreciate that at the time they passed it, but it would have a huge impact on people, I think, over the years.
Let me ask you this: if you're nominated executor, or if you're named by the court, or can the executor sell real estate before probate is complete, or would they have to have some kind of court order? How can families sell real estate if they need to sell it swiftly?
Yeah, it has to be done by court order. One of the least enjoyable jobs is being an executor because, number one, it involves a lot of work, but also it involves a lot of potential personal liability, right? So if the executor sells a home in the estate and then, for whatever reason at the end of the estate, there's not enough money to pay the creditors, the executor is personally liable for that. So yeah, you can sell a home in probate. You've got to have normally court permission to do that. But a lot of the times the executor doesn't, they don't want to unsettle things until they have a clear view of what all the obligations are.
Exactly. That makes sense. Well,
it's because of the personal liability issue.
Right. As you're talking about that personal liability, is there a time limit when a home can be sold, or a time limit that an executor administrator has to perform under?
As soon as the probate estate is opened, those assets in the estate are under the control of the court, and you really can't do anything without a court order during that time. And outside of a trust, that would be the only way that you could possibly change title to a piece of real property is through probate, and it's just not going to proceed until everybody's sort of ready. And how quickly it proceeds and what the timeline is just a function of how busy the court is at that moment. The average time is 12 to 18 months roughly, but during COVID, it got much longer.
Sure.
So those type of things do have an impact on time.
Speaking about the timing, and this sounds like could be average a year, what are some of the most common challenges families are facing when they try to sell inherited real estate?
One of the things is that sometimes the property sits vacant, and as you know, with vacant property, things start to happen, and things are not kept up. Sometimes there's leaks, other damages, and so because of that, they're not getting the best value they can potentially for the property. And I think most of the time when you have a situation where an heir is not going to be continuing to live in the property and you're dealing with it under a will, that tends to happen a lot just because of the delays in probate. It really, if you think about the cost of what it takes to put a home through probate, it's a small fraction of what it costs to set up a revocable trust. So by spending the money to set up a revocable trust, you're making it back, tenfold sometimes or more, maybe 20-fold, maybe 30-fold. So just something to think about. Especially with a situation where you have homes in multiple states, because then you're in a double or triple probate situation. You need a probate estate and a lawyer or law firm in each state that you have property.
Wow, that's something that I didn't know. Are you able to help folks in different states settle and navigate legal proceedings?
It's a great question. So this type of law is essentially state law. There are federal tax implications and a few other, but for the most part, it's based upon state law, so it's slightly different in all 50 states. I'm licensed in Virginia, DC, and New York, maybe adding Maryland to the mix. But when it comes to estate planning, you always need somebody who's licensed in the state that you live in.
I love that. Thank you for sharing that, Kyle.
Yeah.
It's super important. A lot of folks know family friend, know somebody, but you need someone specific to that state.
That's right. Yeah, absolutely. Laws are slightly different in each place, and you need somebody by license in that state.
Wow. Thank you for sharing. That's a huge tip right there. What would you say the biggest mistake is people make when they're in this type of situation, when they're handling real estate through an estate or probate?
Yeah, well, I think a couple things. I think in general, the idea, and I know it's sort of been ingrained, that the idea that a will solves all of your estate planning problems, right? That's just been hammered into people. I need a will, I need that, right? But the fact is that it doesn't, especially in the real estate world, where you have high value assets that appreciate quickly. Probate is not the best place for them because of the expense, and because really, if you're building that real estate empire, you want to pass it on to somebody. And so why would you not want to pass it on in a protected legal wrap, right?
Yeah.
And that's an important point, because under the common law, which is really what trust law is, it goes back to the law of England, you couldn't create a trust for yourself that gave you asset protection. In other words, I can't use my assets under the common law to create a trust that gives me asset protection, but I can use my assets to create a trust that gives somebody else protection, like my child, right? And so if you're doing this for your children, you're giving them and passing them on property in a way that is protected, that they can't give themselves, right? That's only something you can give to a third party. And that's what makes it special, is that you're providing them that asset protection that they can't give themselves.
I love that. You know, as you're sharing this, again, it's so important for folks to talk with you, learn their options, and you're really talking about protecting family here, relatives, your own kids. Thank you for sharing all this.
Sure. Yeah, and you're right. It is so individualized, Norm. There is not a one size fits all, and that's why I always start my process with a questionnaire. And and I try not to make it too overwhelming. It's a 20 or 30 minute, exercise, but it's important because it collects information about a particular person's family. It also collects information on the assets. And that's important because when we sit down, I want to give them advice as to what's appropriate for them, because it's going to be specific to their situation. And, one of the failings in estate planning is this idea that the documents by themselves take care of all the problems. And the documents are only as good as the process that accompanies them. And, I could give you examples all day long of people who've come to me who've went to a documents only attorney and signed the documents and thought they were in great shape. And then the spouse died and it was a total disaster, and the exact opposite of what they wanted to happen happened. And part of the reason is, again, it goes back to the process. And that's why in that questionnaire, I capture that information so that not only do I have that information to draft the documents, but then we have a list of assets that we work through. As the representation continues, I can advise them, my client, as to how do you coordinate that asset with your trust? Do you update the beneficiary designation? Do you change the title? Do you need some other assignment document? But I want to make sure when they walk out of my office that I not only have the estate planning documents, but they understand how to coordinate their assets with that estate plan so that it works. And that is the fundamental way that I've designed my practice, because it is different than sort of the paper shuffling that many estate planning attorneys do. It's what makes this work at the end, as opposed to just being an expensive, false sense of security.
Fantastic, Kyle. I'm hearing you say the way you communicate with your clients, it keeps them engaged and specifically how it affects their life in real time, affects their family's life.
Right.
It's you're able to really add so much value over a tough topic.
Yeah, Norm, that's a great point. I mean, so much of this is how you interact with the clients, right? And having been an attorney, 24 years, what I actually enjoy the most is the counseling of the client, the strategic, right? The planning, like that's what I like to get into. And that's where I think my value is. And the documents really just memorialize that, right? And that's why I say the documents are only as good as the process. The process is in the attorney's brain, and that comes to fruition by speaking with the client and understanding what the client wants. And I don't ever want to be in a situation where I say to the client, you need X, Y, and Z. I want to explain what X, Y, and Z are. And I want the client to decide, yeah, that's the way I want to go. I like that. That's my decision. And I think that's an important part of this.
It's so important. I love giving the advice and then supporting their decisions. Tell me, Kyle, what would you say are best practices around how a realtor and an estate attorney could work together to ensure, a home sale would align with a client's estate plan?
Yeah. So I want to talk to you both about a primary residence and an investment property. So on a primary residence, this is why setting up a trust, at least on the investment side, earlier is better than later, because when you purchase a home or, sell your home and purchase another home, you can title that home directly into the trust, right? When you take title, at the closing, you take it directly into your trust. And that's if it's a revocable trust. And I draft my trust in a way so that Article 1 lays out all the information that the mortgage company would want to see to feel comfortable titling a home in a revocable trust, right? So that's the important part of that. It becomes even more important for somebody that is thinking about investing in a second piece of property, right? That's not the primary residence, that's their investment property. And the reason it's important to act sooner rather than later is there's often, as you know, Norm, due on transfer clause in most mortgages that if you deeded that property over to a trust, they could immediately accelerate the entire loan. There's a law called Garn-St. Germain, and that law says for primary mortgages, you disregard that. For primary residences, you disregard that language, right? Now, when it comes to
primary.
That's right, as to the primary. Now, when it comes to investment property, it is enforceable. So before investment property is transferred into a trust, what you do is you reach out as the borrower to the lender, just explaining you're doing your estate planning. This is a revocable trust. Would you agree to the transfer into the trust? They always agree, right? You just don't want to do it without asking, right?
Sure.
Now, I haven't had one that hasn't agreed. In theory, it could be a business practice that they use to get out from under low interest loans. That may and could violate some federal laws. That's not my expertise, but in practice, they generally don't have an issue with it going into a revocable trust. Now, if you told them you're transferring it into an irrevocable trust, they have some issues with it, and I understand that. But we're talking revocable trust here because they want to. They want to be able. At the end of the day, they want to be able to foreclose on the property if they need to. That's their interest, right? And the mortgage stays in whoever name that it is, signed under. We're just talking the deed here, as to how it's recorded with county land records.
Asset protection, exactly.
Yeah. Is that clear? How I said that, Norm, or was that a little confusing?
No, I thought it was really clear. What I took away from that is investment properties and primary properties are different the way they're treated, and then the other piece of this is just because it's in a trust doesn't really mean it complicates your ability to refinance or things like that. It's just pretty straightforward once you get it rolling.
That's right. Yeah, a revocable trust is meant to be very user-friendly. You can take things out or put things in at will. You don't have to ask anyone's permission as the grantor.
Yeah.
Right, and that's important for people. They're the only beneficiaries. They make all the decisions. There's no tax consequence to putting things in that trust. There's no tax consequence to taking them out. There's no separate tax ID required. There's no separate IRS tax form required. None of that. It's very user-friendly. It all operates as essentially your alter ego, but accomplishes all the estate planning objectives at the same time.
Excellent, Kyle. When you say user-friendly, I need more of that in my life. Anything that's user-friendly, bring it on.
Yeah, no, and that's key, especially in this area, because if you look at the language in my trust, they're written in plain English, because somebody has to pick up that trust and administer it. And if it, is complicated and impossible to understand, it's going to frustrate the purpose. So don't want to do that. So my work is very easily understood and interpreted.
Love that. Gosh, that's excellent. Kyle, I'm thinking about a few questions, and I wanted to ask you, at what point should someone reach out to you for estate and probate advice? And when they do call or reach out to you, what should they have ready when they do?
Yeah, that's a good question, right? People always wonder, when is the right time? Anytime if someone has young children or, beneficiaries that certain they want to take care of, or, they're starting to accumulate assets. Maybe they buy their first home.
Yeah.
Maybe they start to make investments. That's generally the time to talk about it, unless, somebody is already getting, on an age, then you want to make sure you've got some of this stuff in place. But, everybody's situation is different. And that's why I start out with just a 15-minute, introductory call. No pressure. I don't charge for it. It's just for me to understand what is it that's going on in your life? What has you thinking about estate planning?
Yeah.
And then I can help you decide, does it make sense or does it, not make sense? And here's the things I can do. Sometimes I get calls from people who want to get help and do things, but the law just doesn't allow me to do those things. And so I'm very, very straightforward and honest with people. I do not want to do work that doesn't need to be done, and often talk my clients out of sort of more complicated provisions and trusts, because if they don't need it, then why add complexity, right? I want to keep things, my trusts are very comprehensive. They cover many different scenarios, but I don't want to put anything in there that's unnecessary. That's just my general philosophy. So, but yeah, to get back, that's what that initial call is for, just to help people figure out, do they need something?
Absolutely. Just to get their initial questions answered and then feel comfortable about they have a plan for next steps. What's the one thing you wish every homeowner knew about estate planning?
That's a good question. I hadn't really thought about that before. I would hope that every homeowner would, if I could reach everyone, I would want them to know that there are benefits to doing estate planning above and beyond what they probably know about. A lot of people think, well, it's just, I need to get my affairs in order. I need to get my affairs in order. But they don't really think about, and they aren't really sure what that means. But if that meant saving tens, maybe hundreds of thousands of dollars in probate fees for your children, would that interest you? Probably would. Right? If you could get all your property into a trust and make sure you get a step up in basis upon death and wipe away capital gains for all your children, that would really feel really good, right? Yeah. If you knew you could pass everything on to your children in a legal vault that was protected from lawsuits, creditors, and divorce, right? That's pretty good too.
That sounds great.
And I just think a lot of people don't appreciate that you can do these things with estate planning, and it's not unaffordable, right? It's not cheap, but it's not unaffordable.
I mean, just for a minute, what would like a range of be for fees?
So it really, again, it goes back to, not everybody needs the same thing, and, everybody's different. But for most people to get set up with a trust package, it's usually in the range of $5,000, right? It can go up for more complexity. But again, that's more than just a trust. That's everything you need. That's the trust. That's all the ancillary trust documents. It's what they call a pour-over will to back up the trust. It's a financial power of attorney, medical power of attorney, HIPAA release, advanced healthcare directive, right? All the things that you need to have a complete plan and be protected both while you're alive and after you pass away. That's what's included in the plan.
I love that. It sounds very comprehensive. And like you said, you want to make it easier down the road with next steps, and comprehensive is the way to go.
Yeah.
Thank you for that, Kyle.
Yeah.
Well, we are wrapping up. I'd love, if you don't mind, would you share the best way for people to get in touch with you?
Yeah. So I'm pretty accessible. My cell phone, which you're welcome to text me, sort of as an initial point of contact, that's 703-304-8390. My email is kmanikas, that's KMANIKAS @manikasplc.com. My office line, which is 703-520-1400, can reach me there as well. So any of those places, and also you can go directly on my website. There's a contact us. There's a place to also schedule a 15-minute call. So any of those avenues is a great way to initially connect with me.
Perfect, Kyle. You've given us so much good information, food for thought. It made me think of additional questions. So I love that we have a connection. I look forward to our clients touching base with each of us with their own personal questions or comments down below. I'm Norm O'Neill with Keller Williams Realty. Questions, concerns, hallucinations, call Norm.
I like that. It's great, Mark. It's a pleasure talking with you. And of course, save those questions because be happy to do this again sometime.
We'll look forward to that. Thank you everyone for joining.